Let's look at Federalist 81. This is the fourth essay out of the 5 essays that Hamilton writes about the judiciary, about the judicial branch of the government. And again, here he's answering the anti-federalists' criticism of the Constitution. They're saying that the anti-federalists are saying that the Constitution puts too much power in the hands of the judiciary. At first, they were complaining that the national legislature is too strong. It's going to concentrate power in its hands, and states will not have any power. Powers left to them. Then Madison, Hamilton, John Jay tried to answer those criticisms in the earlier papers. Now they say the judiciary is going to be too powerful, and it's going to interpret the laws, interpret the spirit of the laws rather than the letter of the law. In other words, they can pretty much interpret it any way they want to and gradually snatch power away from other branches. Anti-federalists now say, well, this court system, the federal court system, should be actually part and under the national legislature rather than a separate branch. And Hamilton says, no, you cannot expect the same people that pass laws to judge them, because if they make a mistake, they're not going to come and say, we made a mistake. So that's just wrong from the get-go. Because anti-federalists are saying, well, look at Britain. The court of last resort is the House of Lords, and that's a branch of the legislature. And Hamilton says, no, we need an independent judiciary to keep the separation of powers in check, the division of powers to be established firmly, where we won't have tyranny. We won't have government actually destroying our liberties. So here he focuses on Article 3, Section 1, and he actually writes it down in the second paragraph. So let me start reading this. Let us now return to the partition of the judiciary authority between different courts and the relations to each other. So there's a federal court system that the anti-federalists are complaining. They're saying, well, if you give certain things to federal court systems, then the state courts will have nothing to do, and that's how you snatch power away from the states. And states will just be nothing. They will just be called the state and nothing else. And Hamilton says, no, we're not planning on doing this. So he says in the Constitution, Article 3, Section 1 says, the judicial power of the United States is, by the plan of the Convention, to be vested in one Supreme Court and in such inferior courts as the Congress may, from time to time, ordain and establish. That there ought to be one court of supreme and final jurisdiction is a proposition which is not likely to be contested. The reason for it have been assigned in another place and are too obvious to need repetition. The only question that seems to have been raised concerning it is whether it ought to be a distinct body or a branch of the legislature. The same contradiction is observable in regard to this matter, which has been remarked in several other cases. The very men who object to the Senate as a court of impeachments on the grounds of an improper intermixture of powers advocate, by implication at least, the propriety of vesting the ultimate decision of all causes in the whole or in a part of the legislative body. So this is what they're saying. They're saying just put the judiciary included inside the national legislature. Let it be part of the national legislature. And Hamilton says this will be totally wrong. The arguments, or rather suggestions, upon which this charge is founded are to this effect. The authority of the proposed Supreme Court of the United States, which is to be a separate and independent body, will be superior to that of the legislature. The power of construing the laws according to the spirit of the Constitution will enable that court to mold them into whatever shape it may think proper, especially as its decisions will not be in any manner object to the revision or correction of the legislative body. This is unprecedented, as it is dangerous. In Britain, the judicial power, in the last resort, resides in the House of Lords, which is a branch of the legislature. And this part of the British government has been imitated in the state constitutions in general. The Parliament of Great Britain and the legislatures of the several states can at any time rectify, by law, the exceptionable decisions of their respective courts, but the errors and usurpations of the Supreme Court of the United States will be uncontrollable and remediless. So he says this is what the Anti-Federalists are saying. They're saying, look at Britain, look at our state constitutions. Judiciary is part of the legislature. And if you give the judicial branch absolute independence, who would be say that they are not going to interpret the laws, the spirit of the law, rather than the exact letter of the law? And gradually they'll shape the law to their advantage and gradually concentrate power in that branch. So Hamilton says this, upon examination, will be found to be made up altogether of false reasoning upon misconceived fact. In the first place, there is not a syllable in the plan under consideration which directly empowers the national courts to construe the laws according to the spirit of the Constitution. Construe in a way means to read the laws, to interpret the laws. It says there's not one syllable in this Constitution that says the Supreme Court is going to interpret the spirit of the laws, or which gives them any greater latitude in this respect than may be claimed by the courts of every state. I admit, however, that the Constitution ought to be the standard of construction for the laws, and that wherever there is an evident opposition, the laws ought to give place to the Constitution. But this doctrine is not deducible from any circumstance peculiar to the plan of the Convention, but from the general theory of a limited Constitution. And as far as it is true, it is equally applicable to most, if not to all, the state governments. There can be no objection, therefore, on this account, to the federal judicature, which will not lie against the local judicatures in general, and which will not serve to condemn every constitution that attempts to set bounds to legislative discretion. Okay, keep in mind that I've already mentioned we owe the Bill of Rights mostly to the work of Anti-Federalists. So here, if I'm not talking so much about Anti-Federalists, it doesn't mean that I don't appreciate what they did. So we have to give them credit. And as I've mentioned before, actually I think I might have mentioned it when we read Federalist 78. I said the Bill of Rights, the first 10 amendments of the Constitution, half of them have to do with the judiciary. Okay? 50% So when we read these, remember that Hamilton is focusing on the Constitution that was written in Philadelphia, not the Constitution with the Bill of Rights attached to it. That's why I have mentioned many times that go to websites like C-SPAN, okay, and they have a section that focuses mostly on the work of the courts, and you can actually read the history of the Supreme Court or learn about federal judiciary, state governments, and gradually build up your knowledge. C-SPAN is an excellent website. Okay, then you go to places like Teaching American History. They've got a lot of source material organized very well. And the National Constitutional Center, National Archives, you can access lectures, talks by scholars that will explain the judicial branch of the United States government as well as other branches. So you can build your knowledge and learn stuff, learn things a little bit more in depth, just depending on your interest. So Hamilton, Publius, all these three people who wrote the Federalist, they're defending the body of the Constitution that came out of Philadelphia. It did not have the Bill of Rights attached to it yet. They actually were forced. Madison finally accepted that he had to actually guide those first 10 amendments, or what came to be eventually the first 10 amendments, Bill of Rights, through the first Congress of the United States in 1789.